Hey everybody, it's Greg Taylor with Greg Taylor & Associates, and today we're going to talk about estate planning and what is a living trust. Now, estate planning is one of the most important steps you can take to protect your family and your assets. Almost everyone should have, at a minimum, a last will and testament. For many people, a living trust can offer benefits that a standard will does not. Today's video, we're going to talk about living trusts and how they work. First, a living trust is a legal document that you create and fund while you're alive. That's unlike a will, which only takes effect after your death. The living trust allows you to manage and protect your assets now, which gives you greater control over how those assets are handled both during your lifetime and after you pass away. So what happens when you move assets into a living trust? Ownership of those assets is transferred from your name to the trust itself. But here's the key. Even though the trust owns these assets, you're still in full control of them as trustee of the trust. You could appoint anyone as trustee, but most often you're going to appoint yourself so that you maintain full control of the assets while you're alive. You can buy, sell, or use these assets just like you did before. And then if you pass away or become incapacitated, you have a successor trustee that takes over and handles your affairs when that happens. One of the biggest advantages of a living trust is that it allows you to avoid probate. Probate is the legal process of distributing assets after someone's death. It can take months and even years and can be costly due to legal fees and court expenses. However, with a living trust, your beneficiaries receive their inheritance faster without going through a lengthy and expensive court process. It also provides more flexibility because if something happens to you, your successor trustee can immediately step in and manage your assets according to your wishes. Another big advantage of a living trust is that it protects your privacy. Did you know that a will becomes public record once it goes through probate? That means anyone can access details about what you owned and who inherited those assets. A living trust, on the other hand, remains totally confidential. Since it does not go through the court system, your financial information and the distribution of your assets remains private. A common question is, does a living trust cost more than a will? The answer is yes. Setting up a living trust does require a larger initial investment. However, it generally saves money in the long run. Avoiding probate means avoiding court costs, legal expenses, and other costs associated with settling an estate through the courts. This means that more of your hard-earned money goes directly to your loved ones rather than being lost to legal fees and lengthy court proceedings. There are even more benefits to having a living trust, including control over distribution, speed of transition, and making the process easier for your family upon your passing. A living trust is one of the most effective tools for protecting your assets and ensuring your wishes are carried out smoothly and privately. If you want to know if a living trust is right for you, please give us a call. Feel free to call at 270-761-4558 or visit our website at gregtaylorlaw.com. We look forward to hearing from you.